The PDF of the outlines and the matter is available in the description. Get ready. Start. Shri Sanjay Agarwal, Learned Counsel appearing for the petitioner, would submit that the petitioner had deposited the entire amount along with interest before issuance of the show cause notice for termination of the petitioner's dealership, stating inter alia that the dishonor of checks had been taking place for a long time and the petitioner continued to lift the product from HPCL depot without taking corrective measures. Stop. Shri Agarwal would further submit that the account could not be reconciled due to prolonged illness of the father of the petitioner, as well as for the reason that the petitioner was never informed before 1/8/2009. Shri Agarwal would next submit that clause 55 of the dealership agreement clearly provides that if the dealer for any reason makes default to make payment to the corporation in full or his outstanding beyond 4 days of demand by the corporation shall be at liberty to terminate the agreement. In the case on hand, the respondent corporation has not given any such notice to remedy any alleged breach of the clause of the agreement within the stipulated period, and even the show cause notice which was given after deposit of the entire amount also does not disclose that if there was any breach, the dealer was under obligation to remedy the same within a period of 4 days of the receipt of written notice from the corporation. In that regard, thus the act of the respondent corporation is contrary to the provisions of the agreement, unreasonable, arbitrary and discriminatory. Shri Agarwal would further contended that no cause of action has arisen under the provisions of Negotiable Instrument Act 1881, as section 138 of the act prescribes that to constitute an offence 6 ingredients are required to be fulfilled, to say that person who had drawn the checks can be deemed to have committed an offence of the dishonor of checks within the meaning of section 138 of the act. No notice or demand was issued for the payment of dishonor of check, providing 15 days time as contemplated under section 138 of the act. Per contra, Shri Kesav Nath, Learned Counsel appearing for the respondent corporation, would submit that the impugned order was passed on the ground of violation of clause 55 of the dealership agreement. Shri Keshav would further submit that this petition filed under Article 226 of the Constitution of India is to enforce a civil liability arising out of breach of contract to pay the amount due to the respondent corporation, and as such the same is not maintainable on the ground of availability of an alternative remedy in terms of arbitration agreement as per clause 66 of the dealership agreement. The supplies were stopped by the respondent corporation when it was found that there were financial irregularities on the part of the petitioner by not paying the dues. Thereafter, paying back the money does not absolve the petitioner from the wrong committed by it, and the same amounts to violation of the dealership agreement.